Hey everybody, thank you for coming in tonight. I started a little early because I saw the Biggin raid. Thank you, Biggin, and folks for the raid. Thank you so much. Well, we got a lot to talk about tonight. The comments are coming in quick. I have a hard time reading and talking at the same time, so y'all bear with me. Um, we had a heck of a show last night. It was interesting. I think it was neat to get things about. And I'll tell you, the biggest thing that I was impressed about last night was I had to find a charger for my camera. I had to find a power supply for my camera. And damn sure enough, if the power supply I found for my camera was from an old BlackBerry tablet I had probably 15 years ago. So I have proven to my wife that keeping old chargers does make sense. There is a reason I kept all those chargers all those years. An old BlackBerry charger is what works on my Sony camera. So that's a good sign there. Hey, Myco Psycho, Shannon, Roland G, Myco Psycho again, Linus, everybody. Thank you guys so much for coming over. Hey, Nan, it's good to talk to you today on Discord. I'm still learning Discord, so y'all got to teach me about all that. Got some old Judge Oakley, and I've got a new Judge Oakley from Friday. He's got cameras up in his courtroom finally, so you can see everybody in his courtroom. So that's neat there. I got some Judge Fleischer simply because we're all on a Fleischer kick. We miss him, and he'll be back on Monday, so that'll be neat to see. Going through the comments, Linus is gonna have to get some sleep at some point. She got some stuff to do. Hey, Amanda, good to see y'all there last night. I'm gonna go ahead and show who won the best comment for last night. Last night was a heck of a show. I really appreciate everybody coming in, but somebody won the contest of best comments. And let me see if I can throw the comment up here on the screen. 12 Strings at Midnight won the best comment. I think that solved it up. Fozzie actually sent it to me, and I'd seen it and caught on to it. It was funny as could be. He's been lively today also, so that's neat. We're going to jump on a Judge Fleischer one. It's an older one, I think from May, if I'm not mistaken. It's got the date on it. Hey, Credence and Mikey, it's great to see you guys on. I saw y'all bail on last night. Last night was an odd one, so you either loved it or hated it or came in at the middle and didn't know what the heck was going on through any of it. And so, but I'm gonna throw on an old Judge Fleischer, and then we'll catch up in about 20 to 30 minutes whenever that's over.
Sure, Your Honor.
Yep, give me 1 second. Mr. Ariola, are you not going to talk to me? How are you going to represent yourself if you're not even going to talk to me? How's that going to work? Yeah, tell me.
My handcuffs tied behind my back.
I brought you out because Lori, the lawyer I've appointed to represent you, is telling me that you want to represent yourself. Is this what you want to do?
I do.
Why?
This court is threatening me with a program. I'm not asking them. This court has threatened me of such remarks I've never even promised this court.
You have terrorized the people at the Chevron for the last 3 years. And I've told you time after time after time not to go back to the Chevron. Yet you persist and you go back. You allegedly steal. You allegedly destroy their property. They've asked you repeatedly. I've ordered you not to go back repeatedly. Yet the minute you get out, you go back to the property over and over. And you have been arrested at this place, what, 14 times? Pavel, how many times are we talking? 17, 22? You've been arrested over and over. And I've asked you to, time and again not to go back. Every time you do what you're going to do anyways. So what can I do to ensure that you're not going to go back? You have never, in the 3 years and the 25 to 30 cases that you've had with me, have ever once, not once, appeared on your own. Ever. The only thing I asked you to do is not to go back to the Chevron. That's all I asked you to do.
Hey, lean us and throw the goat. I don't know if y'all have any of these in your countries. That's a Chevron. That's actually a safe one. I don't see anyone getting robbed in that Chevron, so that's not a typical Chevron. But Chevrons are just little gas station mini marts. I think this one on this story, I think he's got I think there's a gambling machine in there. I think is a slot machine that he plays and he feels that he takes care of his family with. I think his argument was that's how he feeds his family. So I don't know anyone that's ever won any of those, but that's how he rolls. But we're gonna jump back to it. I like this. I like this case because I like the way Judge Fleischer deals with him. There's obviously some mental things going on. There's obviously some issues. Judge Fleischer makes a mistake and apologizes for it, owns up. That's important for the judges to do. So, yeah, I think it's good to show this one to just show how the system works. And I just noticed one of the first times I've ever seen Judge Fleischer in a normal suit. So, we'll go with that. That'll be something unusual by this one.
So, if you were in my shoes, what would you do?
The court ordered not to go back to the store.
I've done that 18 times.
You've asked me.
Yes.
Not once have there been a
I've
court
asked
order.
you, I've ordered, I've prayed, I've done smoke signals. Everything I've done is to try to get you not to go back.
I wish you was talking here. I'd like to know that. Are we just talking?
Yeah.
I've made my case to this court before. These privileged calls on me about being at the store are made by one man, one employee. I'm given permission to go to the back of the store. And we're just talking here. I made my case. Okay. This here rattles me. It disturbs my peace of mind. Okay. These people know who I am. They allow me to go to the back of the store. There's no interest in any other way around unless I get permission by them. They give me permission. Okay. Later, when shift changes, I believe this is how it always tends to it. It's when the policemen are called on my person. I made my case to this court. I'm just talking.
If you want, I will call them right now to see if you're allowed to go back. But from what we've seen and what the owner has told us, they don't want you to go back. Have you talked to the owner in this before? I mean, I know you have in the past, but
They The individual that we called last time is the listed complainant on each of them, so we usually call him. But we can reach out to the like official owner this time around.
I will reach out now to see. But if what you're telling me when shift change comes, that the person coming in doesn't want you there, then that's when you got to go. I will find out right now. I will call for you to see if they want you there or not. But even so, every time I ask you not to go, you still go anyways. So what am I supposed to do? I don't want to keep you here. We have enough people in jail. It doesn't make me happy having you here, but I got to protect the public.
All right. If I tell you this, I'm telling you this. I will not go back to that store.
And you done told me that before 18 times.
This is why I wouldn't, this is just small talk. I've never promised you nor ever told you anything of such a nature.
You have the phone number?
I do have a phone number.
I'm going to call right now. Give me a second. Let me help Kendra here. As soon as I'm done with her, I'm going to call them myself right now and see whether they want you there or not. And then I'll bring you back out and I'll let you know. Give me 2 minutes. Kendra, can we put it on for Friday, please? Okay, Lori, you with me?
Yes, sir.
Okay, let me just tell you, Mr. Ariola, at the outset, you're not here alone. I have a lawyer, Lori, here with you now so that she can be with you during everything that we're doing so that you're not alone. I want to make sure that you know that you're not, it's just not the world against you. You have someone here that's helping you out with the situation. I had Mr. Kim call out to Syed, which is the person who is the manager, I guess.
He is. So, Your Honor, I spoke with Mr. Shad Syed, and he is the complainant in this case. He stated that he is the manager and business partner of Mr. Mohammed Akhtar. Mr. Mohammed Akhtar is the owner. His son, Siam Akhtar, is also a co-owner. These three, along with the cashier, are the only employees in that gas station. There's no one else there, no one else that can speak for them. All four employees stated that they do not want the defendant at the gas station. The complainant stated that the defendant has previously come in with a stick and another time with a crowbar. He stated that the defendant has also assaulted an officer in another incident. The complainant also says there's a recorded 911 call on one of the incidents where you can hear the defendant admitting that he knows he's not supposed to be there. The complainant believes that the defendant should go to a mental health facility or rehab, but the last time they were in court where he received a conviction from this court, the defendant stated that he was not mentally sick last time in court, and so the complainant doesn't know what to do. The complainant is fearful for his safety and believes that the defendant should be charged with a felony because he was already convicted for trespassing, but he keeps coming back. So he doesn't have a solution. He says he's available for whatever the state needs in terms of this prosecution.
That is from the mouth of the people that work at that gas station. I don't know where you're getting your information that you can go, but you speak. Let me know. What do you?
This is the first time that I've heard that. And it's, again, it's troubling. I am not, how can I say this?
Just say it.
I've spoke, a matter of fact, with the son. He told me himself, he said, "You're okay with me, man. Just don't just leave whenever Alex come by." I am not that. I'm not looking for trouble, nor am I against any of them. I'm troubled with what I've just heard right now. Even the main owner, I know him so well. he tells me the same thing, just as his son. He said, just leave. You cannot be here whenever Alex comes. He's like,
Don't go back. It doesn't matter who's telling you what, how many times they've told you, when they've told you, all their minds have changed. They just don't want you back. They're scared of you, Mr. Ariola. They are scared.
I can only just listen to what I just heard. I mean, okay, this is a different picture whenever I'm talking to them, but okay.
I'm only bringing you here because, like I told you, I want you to understand that you cannot go back. And I want you to understand this. And I'm going to bring you here many times because I've told you this. We've done this before. We've exactly done this exact thing where I've had the district attorney's office call them and tell you this. So I don't know what else we have. And that's why I wanted you to go to the DDRP location to see and have you evaluated. Go ahead.
Listen, what I just heard right now, no, that makes my stomach hurt. It is a whole different story when I'm there with them. Right now, I'm only, I mean, I honestly, I don't want to go back there if this is if this is the statement that came out of who was it?
Spoke with Mr. Syed.
Syed. That troubles me. I have a family. I have a family to take care of, and I'm being troubled by these privileged calls by Mr. Syed. I don't even think this man. I don't hate this man. I'm just troubled about what's being, many ways.
You shouldn't let it trouble you. It doesn't matter. Just don't go back. It shouldn't make your stomach hurt. It shouldn't trouble you. None of that matters. Just don't go back and everything will be fine.
Believe me, yes. Now that this statement was made, believe me, I have a family to take care of. I really don't say much because I just want to get. I'm not here for no excuses or nothing. I can only bring the facts of it all. Okay, I have a family to take care of, and my time is being taken away from me being able to provide for my family. I was with my family 5 days. 5 days. When I went to the store just to talk to a friend, and that friend was the son, and he told me, he's like, it's okay, Ronnie, you can be here, just leave whenever he comes. I'm like, okay, man, I don't really even.
That's the problem, though. The problem is you never know when the guy's going to come back. You never know. What if he comes in 5 minutes after he told you? You never know. That's why the best way is not to go back at all.
And I'm perfectly sane. I know from right from wrong. I'm not committing no crimes. I'm not intentionally, going out there committing crimes, even that by doing drugs or any of that.
We need to figure out where we're going to go from here because I don't know. So let me talk with Lori, your lawyer. Let's figure out a path where we're going to go from here. We sent you to the facility for you to get evaluated, but you left. And after you left, you went back to this place, you picked up a new trespass case. So I don't know where we're going to go from here.
What do you mean I left?
You were ordered to, and you agreed with me that you were going to go to this residential facility. You agreed with me.
No, the trial, I lost the trial. You put me in this facility.
Correct.
Okay, and I guess
You told me at that time that you were willingly going to go because you wanted things to change and you wanted to better yourself.
I'm not asking for treatment. I'm here as a man right now. I stand before you. I stand before this court. I am not asking for treatment. I'm
Then I'm at a complete loss of how to go forward, Mr. Ariella, because I don't know what.
What do you mean that I left the facility? The facility that you sent me, I completed.
He completed it April 23rd, 2020.
Oh, I thought he took off.
No, he completed it.
Oh,
but
wonderful.
he
So
bumped up
but
the
what happened though? You completed it, he got out, and then you picked up a new trespass.
in less than 10 days. Once he got the-
In less than 10 days. This is the privileged call. I'm asking the court to recognize this. I am not intentionally doing something, passing the line or jumping over a fence or sneaking in behind. I'm asking that this court recognize this privileged cause is taking away my time. I am not on drugs. I am not on dope. I am simply just at a place.
So
at a
let's,
moment.
I'm gonna put you back. I'm gonna let you talk to Lori, and Pavel and Mr. Kimball, I will talk and figure out where we go forward, because I just don't know. I don't know. My only concern is I don't want you to go back. That's all I want.
If I tell you this right now, man, I promise you today, right now, that I will not go back to that store. I'm telling you right now, because this is troubling. Not like you said, I do not want it to trouble me. I promise you this court, I will not go back to that store.
Let me talk to Lori and see where we go, okay? I don't know. And I wish I could believe you. I really do. But given our history, it's very, very hard for me to do that.
I just want you to, please, you sent me to this treatment. I completed it. I did all that was told of me. I didn't get no write-ups, no so-called VRs from that treatment.
You get out of the facility, and less than 10 days later, you went back. That's the rub.
I'm not, how can I say this? It's not like I was visiting a friend.
You're going back.
I understand. I understand this. I mean, this is the way I'm just talking here, and I'm just talking, and
Don't.
I'm not going to go back. I'm telling you this right now. I'm not going to go back. I'm not going. This is me telling you for real that. This is me telling this court.
I need to record this so
Yeah.
that we have this conversation in 2 weeks. If you were to get out, we'll see. I just don't know. Let me talk to Lori, and we're going to figure out where the proper, how to go forward, Mr. Ariel. I just don't know anymore.
Thank you, Judge.
Hey everybody, I threw up a picture of what roller dogs are. They're pretty much toxic things that look like food, but if you have a Monster or Red Bull, it kills all the germs in it and makes it healthy. Just watch the construction workers during the day; they love them. But as far as for regular human consumption, I think they're only legal in the United States. I don't know any other country that would allow that. So here we go for the rest.
Lori, I don't know, man. I'm at a loss what to do.
All right, actually, I'll speak to this. Yes, good afternoon. Good afternoon. So, we spoke previously about Rolando Ariola. Is he allowed into that Chevron?
No, sir. We give him many chances to straighten up and it's causing.
Turn it up.
I've given him multiple chances and it's better to keep him off the property. So it's no problem with our customers and him.
And would you want him back on the property, on the Chevron property?
No, sir. It's the risk of losing my job also.
That's Alex. That's Alex.
That's Sam.
That's Alex.
Hey, I'll go ahead and address this. Daily court dockets. Yes, this is old. Judge Fleischer was off this week. Several people enjoy Judge Fleischer, and so we decided we'd throw it up there. That's the second comment I've seen about that. So yeah, it's definitely old. There you go. It is an old case. In fact, I even put the date on there. I think it was May 10th or May 11th of this year. So this is definitely old.
That's Sam.
Sam.
That's Sam. That's who they requested me to contact.
It's not, I mean, I want the person that he's been saying is allowing him to go on the.
That's Cyan. That's him. That's
That him?
That's him. That's him.
He's telling you he don't want to go. He don't want you there.
He's telling me now, right now. I just heard
That's
it.
him.
I just not heard it from him. I just not. Max question.
Sure.
Cyan.
Yes,
Cyan, this is Roland.
yes.
My brother, I know that I've spoken with you. I was just telling the judge that you have allowed me on the property, and I was just telling him that you would allow me on the property, and that's the only reason.
I can't, it's, the company's policy is they don't want you on the property. I can't risk of losing my job. I'm sorry.
No, yes, Sam. I agree with that. I'm here. I do understand your position. I was just explaining to the judge that it was a friend of mine, which is you, that would allow me. But then in return, it was Alex that would have a different thought. But yes, I do agree. I'm yes, you do your job.
Are you going back, Rolando?
No, I'm not going back. That's my friend. That's his job, and I'm not going to.
I think that's all. We do anything else from?
Is it Siam?
Sam, yeah.
Siam,
Yes.
this is Judge Fleischer. Okay.
Sir, how you doing?
Hey, thank you for being understanding and speaking and taking the time to speak with us. I
Yes,
know, and I'm trying everything in our power to make sure that Mr. Ariola doesn't go back. And
sir.
we are trying to work a program where he's going to be doing a couple classes now. And
Yes, sir.
we are going to release him, but I want you to let me know if he goes back. Okay? Don't go back. You understand?
I told him just tell him to stay away. It's better for his,
Right. He is under the impression that someone is still allowing him to go to play the slot machines or whatnot. And so that's what
No, it's allowing him. There's nothing like that.
you heard it here.
This moment in time, sir. This is just
Heard
now.
it on the stand last month when we did this as well.
There's
No,
Yes, this is a
Excuse.
different, no. This is a whole different process now. That is my friend Sam, and he's in a different position. I'm not gonna jeopardize his job just because of my ignorance or stubborn way, or just to want to go visit him at that.
okay. So where are we at now?
Well, we're asking to put him on a probation and let him do decision-making classes,
You've never once in the 25 cases that we've had together, not once appeared for court. So tell me, how is this any different that if we let you out on a probation now, that you're actually gonna get this done?
I'd like to be able to complete what this court is asking me of and move on forward with my life. I have a life to attend to, children that I provide for. Right now, my financial problem is a whole different ballgame of mine that I gotta take.
So hold on a second. Can we pay for the class so that he's got it for free?
Yes, but it'll take time.
I'll pay for it. How much is it? Is it like 25 bucks, 50 bucks?
No, he's doing thinking for a change, correct? Or.
What are we doing?
I thought, are we doing thinking for a change?
That's what I was.
Oh, okay, yeah, thinking for a change.
How much is
So
it?
it'll be based off the provider, but I believe they're like $50 per class.
And how many classes are we talking?
Yeah, 13 weeks, and I think they go 3 times.
Oh, Lord.
That's why I said if you go through Harris County, it'll just take some time. So it'll take maybe like 2 months before they get answered. So we'll put him on the wait list to get into the program through us, and he'll just have to wait.
I'm gonna have you sign an affidavit with me today. And I want you to promise me that you're gonna do this. What is gonna happen if he fails to do this, Lori?
If he fails to do this, he comes back in and he's looking at going back to the program that you want to send him to see if he can get it.
Right.
I will continue to send it back so much you think I've made it a new career for you. I will send you back and I'm going to send you back and it will be time after time after time. Do you understand? Are you really telling me, Mr. Ariola, that you can do this? Yeah.
I could pay for the classes. My financial problems on the one hand, I mean, I can make things happen. I'm not asking for charity or anything. I just want to finish what the court is asking me of so I can move forward with my life. I got it.
I will give you the chance, Mr. Ariola, but I'm going to tell you now, if you play with me, don't play with me, Smokey. You do?
Judge, can we request to put the affidavit on the record? That way we can make a record of it.
Ramona's gone. Ramona, you're not here, are you?
No, Judge.
She gone. But I'm gonna have you sign a promise with me that you're gonna do it. Mr. Ariel, I'm telling you, if you don't, you're gonna be coming back so much. It's really gonna be a miserable experience. I want to give you a chance. You've heard it from everyone that they don't want you to go back. I will literally explode of anger if you go back to this place one more time. All I want you to do is this class, that's it. This is the last opportunity you will get from me. You understand?
Understand.
Lori. Okay.
Okay, I'll write up a plea then.
All right. I want to say,
Bond conditions on Keener. No contact, no weapons.
Yeah,
All right, Mr. Ariola. I really hope you do well. I really hope you do well. I never, ever want to see anyone fail. And I'm really not asking much from you. There's only two things. Don't go back to the Chevron. And two, get the class done. That's it. You understand? If you don't, and if you go back to this location, I'm going to put you back into the same program that we did until it takes. You understand, sir? And I don't care if you're kicking, screaming, crying. I promise I'm going to do this. I'm going to promise unicorns. I'm going to promise Bambi. I'm going to promise Thumper. Don't go back. Are we clear?
Yes.
You've heard it from everyone. You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You understand that we're doing a probation today. I'm going to have you sign an affidavit. This is a promise that you're making to me today, that you're not going to go back to this location. If you violate this, I can hold you in contempt and put you in jail for 180 days every time you go back to this location. Do you understand? Okay. How do you plead to the offense of criminal trespass? I will not find you guilty. We're doing a straight. Okay. I'm going to find you guilty. I will sentence you to 180 days in jail, but I will probate that. How long then? For 2 years. That means I'm watching over you for 2 years to make sure that you're not going back. Are you going to be able to complete this?
I will.
Okay. We shall see. I really hope so. So the only thing we're doing on the probation is thinking for a change. And then no contact with the Chevron, no going to the Chevron.
That's the court ordering you not to go to that Chevron, you understand?
You've also heard it from Siam and everyone there. I'm taking all your fees away. You don't have to pay for anything. All you have to do is show up. If you fail to show up, I will issue a warrant for your arrest. I will not have any sympathy if you fail to do it or if you go back. If you go back, I swear I'm going to explode from anger. Do you understand, Mr. Ariel? Okay. Good luck.
Hey everybody, I'm gonna take this chance to talk with that what's fellow's name, daily court dockets. Get on Discord, man. Discord, we've got a Discord, we've got a good Discord going. Also Court Vibes is another great channel that you can get on Court Vibes. Get on Court Vibes. It's a great Discord, and you'll learn a lot about the court channels from there. Follow what you want to do. Follow what you want your channel to be about, because all the channels are different and the rules are different. For example, my channel is not monetized. It may be because I'm not showing my face enough. It may be because I'm not doing enough. But we're not going to worry about that. We're going to enjoy and we're going to do what we do. But make sure that your channel is the way you want it to be. All right. This video is over. We're going to jump over to a Judge Allen one. This is another old one. This is a good one that I like with Judge Allen's. I'm going to jump over there. It's about a car getting repossessed. I'm going to throw it over there.
All right. Looks like we're up and running. This is case 16-1461 GC. This is LAFQ versus Vital. Mr. Burnett, you're here on behalf of LAFQ.
Yes, good afternoon, Your Honor.
I think you're actually standing in for Mr. Timothy Smith. I think Mr. Smith is the attorney of record with regard to this matter. Is that right?
That is correct.
And Ms. Vital is here representing herself. Matters before the court because Ms. Vital has filed an objection to garnishment. I don't know if you've had a chance to familiarize yourself with the file, Mr. Burnett.
I have very briefly, Your Honor. I don't believe we actually received the objection. I don't know if maybe perhaps the defendant just filed it with the court. I don't know if we received a copy.
Well, let's see if she can just tell us why it is that she's objecting to the garnishment and see if we can go from there. Ms. Vital?
Because the vehicle was, if that's what it's for, which I'm assuming, because I don't believe I ever had anything else with LAFQ. For the vehicle I was purchasing with Sundance, and they repossessed the vehicle, and then I believe, I don't know if I disputed it, but I had seen that it was disputed or something on the credit report, and I don't know, but I only had the vehicle for 2 months. The guy came and repossessed it. I called and was going to make the payment that following Monday, I believe it was, because it was repossessed on a Friday. And I mean, I don't remember really, it was quite a while ago. I do remember him slamming into the back of me and my parents' driveway, though. That I remember. And damaging the vehicle and myself somewhat. You know, I didn't go to the hospital for it, but yep. But they did get the vehicle back, and I told them, okay, no, because they said, okay, in order to get it back, when I called LAFQ, I would have to pay the full amount. I couldn't just make the payment owed. I said, okay, never mind then, because I had that amount on me to make the payment that was owed, and then continue to make the payments. But they said if I couldn't pay it in full, then that was that. So I said, oh, okay.
Okay. Mr. Burnett?
I don't remember the lady's name that I spoke with at
You don't have to
Black
remember
Key,
that.
but
Let's give them a chance to respond.
Yes, thank you, Your Honor. I do feel for what Miss Bridell's saying. Unfortunately, it appears the time to litigate these particulars has come and gone. There was a judgment entered against her, and what I'm seeing is 2016. She failed to answer the case, and that is what led to the judgment and to us ultimately seeking garnishment of her income taxes. I'm certainly more than willing to discuss matters with her regarding a payment plan or trying to figure out something that works within her finances so that she isn't.
Hold on for just a second, because I think you're getting ahead of us.
Okay.
I'm not sure that she even understands what you just said from a legal proposition. Do you understand what he's talking about? She doesn't understand what you're talking about. So let me see if I can try to explain to you. When you purchase a car, the car is collateral. It's security for the payment of the debt that you owe for the car. So what they do is, when the car is not being paid for, they come out and repossess it, like what you just said. But even after you pay for, after they take the car and they sell the car for whatever they can get for it, I've never actually seen a situation where they sell the car and there's not still a deficiency that you still end up owing because of the loan you originally took out with LabQ. So there's almost always going to be some money that LabQ is going to be able to sue to try and get, because of the difference between what they sell the car for, because I don't know that they've ever been in a situation where they've sold the car for the value of what it is that you owe. I've never, ever seen a situation where they sold a car and you had a refund because it was that much value in the car. It's almost always the case that the former owner of the car still owes some money. So what Mr. Burnett is actually saying is that once that judgment was rendered, when they sued you for what was left on the car, you can't come back and then what we call a collateral attack on the judgment in terms of a garnishment objection. Because now what you're trying to say was, well, I should have never had this judgment against you. But,
not $25,000.
but you have to.
That's
you
double
have to
what
do-
the
You have to do that
car
at the
was
time
worth.
that lawsuit is filed against you. When you are actually, I mean, the judgment is final at this point. And so you can't come back and say, well, I want to open up the whole thing all over again and attack the reason that they even have a judgment against you. I'm trying to explain it to you in simple terms. The people that make the rules are not people like you. People that make the rules that we're playing by are people that own financial institutions.
People like me? What do you mean, people like me?
They're
What kind
not
of people
they're not
am I?
They're not consumers. They're not people that are taking out loans. These are business people.
Oh, so
that go to
business
the-
people aren't consumers and don't take out loans.
There are
Wow.
people that, there are people who are trying to protect themselves. They're not trying to protect you.
Well, I get that.
So that's why I'm saying that, you know, a lot of people struggle to understand why it is that they can be able to do stuff like that. Because they write the rules.
So what we're saying here is I now have to come up with $25,000 for a vehicle.
I don't know.
I don't have and had for 2 months, and then they repossessed, and I tried to make the payment to them and they said I had to pay.
Try to be patient with me
Full right
because
there.
I'm just simply explaining to you how this works. Getting impatient with the explanation is not going to help you. I'm trying to actually help you to understand how this works. So Mr. Burnett is basically saying to me that he would like to talk to you to see if he wants to set up some sort of a payment arrangement. It's up to you if you want to do that.
What was the garnish sheet thing? What does that mean? That they're
They
garnishing
have
my,
again, because of the folks that, and it's not necessarily the credit union that did this, they go to the legislature and they get laws that allow them to do things like go after your tax refund. So that's why we're here today, is because they're looking to try and collect on the judgment that they have. So anywhere that you have a pocket of money, they are allowed to go and try to get it. There are some exceptions where they can't get money. But by and large, they can go after just about anything that you have as an asset.
Yeah, I don't think I have anything as an asset. My parents pretty much handle my money, and this insurance agent who,
Well, I'm not trying to
and
get
it's not even my money, it's money my father's put into something for me,
again,
but yet it is my name,
let
so
me
I guess you
stop-
can go after
let me
that.
stop you because we're losing focus.
Mhm,
Okay,
mhm.
I am again just trying to simply explain to you how law works.
Mhm.
So you can make a decision about whatever it is that you want to do.
You guys can look into whatever, see whatever's there and have it all. Good day. Ready?
You gotta finish your case.
I think I'm done.
No, you're not.
Yeah,
Not with the judge.
I mean, I don't understand here what more you want.
I don't want anything. I was trying to simply explain to you.
Yeah,
Really,
I
you gotta
think
be
I
polite.
understand.
You have to be polite and wait until the case is over.
She can wait.
I think we're done here, right?
Yes, your objection to the garnishment is denied.
Mm-hmm.
Okay, you're free to leave.
Thank you. You have a great day.
You didn't accomplish anything.
There's something to be accomplished. It was already decided before I walked in this room. Let's go.
Sorry.
Thank you, Your Honor. And I would like to thank your staff as well for giving us a heads up about the hearing today.
I like how she tried to get the garnishments taken away. You can't blame her for trying, but you know, it wasn't going to work for her. Definitely got some attitude there. I'm going to throw on a funny old Judge Oakley one. It's a sovereign citizen one. Got somebody that's going to join us that she's never seen it. So I'm going to throw.
All right, appearances for the People versus Frank Mishaw Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not for you how it works.
Yeah,
You're on Friday.
Okay. Are you representing at the desk, representing yourself?
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen and.
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on a record?
Yes.
Are you on your oath to the Constitution?
Hold on, are you picking him up? That's one of the reasons I want you up here, is there's a microphone here.
I'll speak loud.
Are you picking him up?
Yes.
Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
to not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I've recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record. I'm fine.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today,
you have a jurisdictional argument you want to make?
Well, I served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional
argument? I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
Courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the record. Is it?
My jurisdiction.
It's only two.
Sure. Shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
this? Is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
you want to see it?
Affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so.
You said you wanted a sworn complaint.
From an injured party. Who have I injured for the record?
The state of Michigan.
How can I
are bringing the charges?
How can I injure the
state?
Sir,
sit down. Sit
down.
I'm not. Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge. The people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay, all right, and would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt, and we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom, and I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness, yes.
Sir, you are in contempt of court. That's $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is okay. So right here,
this is the probable cause hearing.
It says it's
all right. Stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied? Not
because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objection to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing and that I did not.
They're the same thing, Mr. Michaud.
On this,
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever
columns?
had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it? Because if it's a hearing. or
You
a conference,
didn't
right,
waive it.
so
There's nothing to
do
hold.
I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to—
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
criminal what?
Bid bond.
Hold on. What?
I requested the bid bond, the performance bond. I have the affidavit.
There is no bond.
There are bonds. This is
okay, listen. You can't tell me something and then just disagree with me and think listen to me. Sir, I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of that.
United States citizen. I am
Stop,
actually
hold on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean,
prove it.
It should mean something because.
Prove it, please prove it.
Can I prove what?
Prove that I am the artificial person.
I can prove you're Frank Michaud.
I have full faith and credit.
I can prove.
Okay, so.
Hold on, you've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And
you proved it for me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
Okay.
But you still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
listen to me, Mr. Michaud.
You have.
I've wasted too much time with you. Yes or no?
So,
sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
I object to that. That's
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
Under color of law.
I can give you more than 30 days.
30 days.
I don't think we're gonna use you today. Have a good day. Be safe. Good to see you, John.
Property-wise, you want to give to your wife, sir?
Hey, Ryan,
Yes, sir.
let me know what the next one is.
Is this okay that I give this to your wife?
Yeah.
Once again, your wife.
John, ask the wife to come in so he can see his property go to his wife.
Thank you, Judge.
It should be the Jackson.
Ma'am, would you accept some personal property from your husband, please? Thank you, ma'am. Thanks for the attempt, Mr. Sullivan.
Judge, ready for Jackson then?
I'm ready if they are. You got anything else on the docket today? Sure.
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. I'll let him engage me and, I don't mind that, but I just can't let him try to run things.
Yeah. No.
Especially when I got 3 or 4 more exams to do.
Right. Yeah.
The internet is the worst thing in the world for these guys.
It's like, there are, I'm sure, constitutional law scholars that appreciate this level of abstraction, but like, I tried to tell him.
Don't play here.
The court is going to deny your objection. Let's allow this to move forward.
And you know what?
I thought maybe you'd allow me to just represent him in the limited capacity of like, I know.
I would have if he would have.
I've got a cross prepared. I think that he might have been able to like win this.
And that's the worst part about all these cases, right?
Yeah.
Because sometimes they've got a chance if they just.
We had a good
Ron White, right?
Yeah.
Got a constitutional right to remain silent, just can't do it.
Yeah.
No, I appreciate you trying.
Yeah, thanks, Judge. If the court wants to keep me like, you know, on the, when things are scheduled.
Can we do that? I mean, it seems like he's not antagonistic to you.
Yeah, well, I will know how you.
Yeah. Yeah. No, if you decide tonight, I'll be here. Thank you.
Yeah, thank you, Mr. Sullivan. I appreciate it. Are we ready on this one?
Yeah.
Yeah, good. All right, gentlemen, your appearances for Stacy and Dwight Jackson. All right, appear.
All right, everybody. He was charged with illegal gun from an illegal. He was a convicted felon with an illegal gun at the airport. So that's what he got charged with. Here's the second one where he got to go see another judge. It references him being in jail on contempt for something else. But everybody that was saying that they wanted to see him, here you get to see him in a jail cell. So here we go on that one.
I am the beneficiary of the Frank Anthony Massot Junior Estate, making a special appearance, not general, and I appoint you as my trustee for the record.
Is it Mishu?
Michaud, I believe.
Michaud, thank you. Your appearances, please.
Judge, I'm not sure if we're waiting for the prosecutor, but on Mr. Michaud's behalf, I would say that I'm not sure if Mr. Michaud wants me to continue to represent him. I think he's expressed previously that he does not want me to continue to represent him. I'm happy to be here as some sort of standby counsel, but I prefer that Mr. Michaud sort of speak to whether I'm representing him or whether he intends to represent himself.
Give me one moment so we may get the prosecutor's appearance.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Thank you. And Mr. Michaud, your name for the record, sir.
I am the beneficiary of the Frank Anthony Massot Junior Estate, making a special appearance, not general, and I appoint you as my trustee for the record.
And Mr. Michaud, were you able to hear Mr. Sullivan indicate that he is standing by as shadow counsel?
I heard him.
Okay. This case is scheduled this morning for PCC. How are we proceeding?
I'm here challenging the jurisdiction for the record, ma'am.
Judge, the people are prepared to set a preliminary exam in regards to this matter.
Mr. Michaud, you're able to raise that at the exam date, the allegations that these events occurred at Detroit Metro Airport, which is located in the city of Romulus. Are you ready to have the exam scheduled, sir?
I'm not here to
Mr.
have an
Michaud?
exam. Still trying to wonder why we moving forward with even having an exam, especially after not having, by the due process, even having a probable cause hearing.
It's not a problem, it's probable cause conference, sir, at which time the parties will indicate if they're ready to proceed to exam, if there's a plea or a waiver or some other resolution. So at this time, the assisting prosecuting attorney has requested that an exam be set. Are you prepared to have the exam scheduled?
No, as me here challenging the jurisdiction for the record, I want to put on the record that once the jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That's Mello versus US for the record.
And sir, what is it that you find, what is your allegation regarding the jurisdiction?
Well, what is the jurisdiction that the court is operating up under, ma'am? The Sixth Amendment.
The court is already,
the right
Mr.
to know.
Michaud, the court has already indicated that the allegation is that this event occurred at Detroit Metro Airport, which is located in the city of Romulus.
Under
Are you
what
indicating
juris-
that this event that brings us here to court did not occur in the city of Romulus?
Well, I would like to know what jurisdiction is this court operating up under so that I can properly defend myself and represent myself for the record. So the Sixth Amendment grant me the right to know the nature and causes of these actions. So I would like to know what jurisdiction are you operating up under?
Sir, what the file indicates is that there's an offense dated February 23rd, 2021. And again, that the case happened at Detroit Metro Airport, which is located in the city of Romulus. That is a jurisdiction within this court's parameters. So that being the case, would you like to have an exam scheduled?
No, I would like to have, under what jurisdiction are you proceeding with for it so I can properly defend myself? Under what jurisdiction?
I've said it three times already, Mr. Michaud. If you have indications or information that the event as alleged did not occur in the city of Romulus, I'll hear it at the exam date.
That's not a jurisdiction. The jurisdiction has to either be one or two. Is this common law or admiralty jurisdiction, or is, for the record, you gave me a location,
Michaud?
the jurisdiction.
Mr. Michaud, respectfully, what we'll do this morning is either schedule an exam, adjourn the PCC, or waive the exam. One of those three things.
Well, the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. That's Higgins versus Levine. So I still would like to know under what jurisdiction so that I can properly defend myself, not the location. I need to know what jurisdiction is this court operating up under.
Mr. Michaud.
It wouldn't be a violation of your oath to office to tell me.
Mr. Michaud, for probable cause conference, and I'm sure that you've heard this before, we're doing one of a few things. We are scheduling the exam, we're adjourning the PCC, or we're waiving the exam. How are we proceeding?
We can't proceed until jurisdiction is proven on a record so that I can fully have an understanding of what's going on. I still don't understand what is going on without jurisdiction being proven on the record.
What don't you understand, sir?
I don't understand what jurisdiction are you operating up under. I have the right to know. And are you denying me my right to know what jurisdiction are you operating up under? Because it is your constitutional oath to let me know what jurisdiction it is that you are operating up under. And you still have not yet.
This is the 34th District Court, Mr. Michaud.
That's not a jurisdiction. That's not a constitutional jurisdiction, ma'am. Is this common law or amity? Is this criminal or civil?
It's a criminal case, sir.
Okay, if this
It's a criminal case where it's alleged that you were a felon in possession of a firearm and that you carried a concealed weapon, that's count 2, and then count 3, felony firearm. Those are the allegations. I've given you the 3 counts in this matter. I've given you the date of the offense, and I've given you the location of the offense. We can do one of 3 things this morning, sir. We can adjourn the PCC, we can schedule the exam, or you may waive the exam. Which would you like to do this morning?
I want to have my rights given to me, and my right is to have the jurisdiction of the court. That's just for the record.
I've already indicated to you, sir, what the court is.
Is this common law or amity? That's the only jurisdictions that we can, that I know of. You still haven't acknowledged neither one, and I still don't understand what's going on. Until you acknowledge one or the other, we still haven't got jurisdiction on the record.
Mr. Michaud, do you intend to represent yourself in this matter going forward?
I would like to know jurisdiction so I can properly proceed to present myself properly. I can't properly present myself or defend myself without knowing what jurisdiction that you're operating up under. And you said it was criminal, so if it's criminal, and for a crime to exist, there must be an injured party, a corpus delicti. There can be no sanction imposed or penalty imposed on one because of this constitutional right. So if this is a criminal, where is the injured party? Who have I injured? I have the right to face my accuser, face the one who is bringing these allegations against me, ma'am.
Mr. Michaud, if you wish to be able to defend yourself and hear witnesses against you, the court is happy to schedule the exam. Is that what you're asking this morning?
No, as I appointed you as my trustee, I demand that you dismiss these actions for no corporate select tie, no proper jurisdiction, for no proper crime, injured party.
Mr. Muhammad, your response to Mr. Michel's request that this case be dismissed.
Judge, the people's position is we would object to dismissing this case on the basis of lack of jurisdiction. As you mentioned earlier, this crime did occur in the county of Wayne, and thus we do have jurisdiction.
There is no jurisdiction without an injured party, for the record. So I would like to face the injured party for the record.
And Judge, my response is, then we should
Yes, sir.
then I believe we should set this for a preliminary exam.
I object to that, ma'am. You cannot proceed without jurisdiction being provided on the record. And you being my trustee, for the record, ma'am, you have to dismiss this case as I demand, for the record.
Your request to have this matter dismissed is denied. Mr. Michaud, my question will remain the same. Would you wish the court to schedule an exam? Do you wish to waive that exam and have your case bound over to Third Circuit Court, Frank Murphy Hall of Justice? Or do you wish to adjourn the PCC? Those are your options this morning, sir. They're going to stay the same.
I would like for jurisdiction to be provided for the record, and that if not, I demand dismissal for the record.
This case will not be dismissed, sir. Would you like the exam scheduled? Would you like to waive the exam, or would you like to adjourn the PCC?
Again, jurisdiction for the record. You cannot proceed without, when once jurisdiction is challenged, again, the court cannot proceed when it clearly appears that the court lacks jurisdiction. The court has no authority to reach matters, but rather should dismiss the action. That is Mello versus US.
Mr. Michaud, this is the last time that I will say this. I've indicated to you that this court is the 34th District Court, that this case is criminal in nature, and the allegation is that it occurred at Detroit Metro Airport, which is located in the city of Romulus. If there's something you wish to present, you may do so at the exam. You may present your motions at the exam date. So do you want an exam? Would you like the case to be waived? Or would you like to adjourn the PCC to confer with Mr. Sullivan?
No, I would like for this case to just be dismissed because the lack of providing a proper jurisdiction would make it seem like there is some secret jurisdiction being held against me without me knowing, and I don't consent to any jurisdiction that you have presented. I reserve all my rights for the record.
Understood. And that being the case, Mr. Sullivan, is there anything you'd like to add, sir?
Judge, I don't know what to say. I'm not sure that that I still have authority to represent Mr. Michaud. I will say that Mr. Michaud has made his arguments, a couple times, and I think that the arguments have been, or the motions have been denied. And I've explained to him that those motions, his arguments are preserved on the record, and that he maintains the ability to appeal any denial of his motion to dismiss. He would be able to appeal that first at the circuit court level and then up to the Court of Appeals. So I've done my best to advise him of his rights to continue making that argument. I will also, I think the court may already be aware that Mr. Michaud is not in custody on this case. He's in custody on a contempt of court that Judge Oakley sentenced him to back at the end of January. So I don't know that there is, unlike clients that are in custody, a reason to expedite the setting of the preliminary exam. So I really, I want to defer to Mr. Michaud's stated interest, what it is that he wants to do with this case. I've given him advice, and I don't know what I can do beyond that. Again, I don't want to create any conflict in my representation.
And Mr. Sullivan, the court wasn't asking you to. The court has heard Mr. Michaud's arguments. The record has been made. Your statements have been preserved, Mr. Michaud. And at this time, The court can do one of two things. We can schedule you for an exam next week. We have space available next Wednesday, the 28th. We can adjourn this matter for another PCC next Wednesday morning at 8:30, or you may waive your exam. Your response is one of those three things, please, sir.
Well, my response, I want to ask you a question. Are you honoring your oath to the Constitution today?
Yes, sir.
Okay, and I accept your oath, and upon you honor your oath.
Then Mr. Michaud, no. I've answered your question. I've now given you your options multiple times. The court has other cases. Are we scheduling an exam for next Wednesday? Are you waiving your right to have the exam? Or would you like another PCC next Wednesday morning at 8:30 so you have time to consider your options and how you will proceed in this case?
I demand a dismissal for lack of jurisdiction for the record.
Your request is denied, sir. The record's preserved. If you wish to appeal that decision, you may do so in writing properly filed. Again, exam, waiver, or adjourn PCC.
Dismissal for the record. I demand that you dismiss this you cannot move once jurisdiction is challenged, the court cannot proceed for the record, ma'am.
And Judge, for the record, the people would like to request a preliminary exam. There will be no plea offer. We did already have a probable cause conference in this case, so we are prepared to move forward, Judge, just for the record.
Mary Ann, is there space next Wednesday afternoon?
Yes, Judge, at 2:30.
I object. Court cannot proceed without jurisdiction for the record. Jurisdiction has not been provided for the record so that I may.
Mr. Michaud, the court has responded and provided the appropriate information to you. The exam will be scheduled for next Wednesday, February 28, 2024, at 2:30 p.m. in person here in courtroom number 1. If there is a motion that you want the court to consider, the court will take it up as a preliminary part of the exam.
I object.
Anything else, Mr. Mohammed?
Nothing from the people, Judge. Thank you.
Anything else, Mr. Michaud?
I demand for a dismissal for the record. Court cannot proceed without jurisdiction being provided for the record, and yet you still continue.
Your oral motion having been heard and denied. Anything else?
Why are you denying to put the jurisdiction on the record? Why? I just want to know why. Why are you denying?
I've done that, Mr. Michaud. I've done that. I've asked you multiple times how you would like to proceed with this conference. You refuse to answer the court's question regarding how we're proceeding. The prosecution has requested an exam. The court has scheduled an exam. If there are things that you wish to take up preliminary next Wednesday, we will take it up before the exam starts.
I'm not prepared, do not wish to have a preliminary without me knowing how to defend myself under which jurisdiction. So it's still a violation of my rights, my due process. You're moving forward without telling me which jurisdiction so that I can properly defend myself and represent. Civil and criminal procedures have different jurisdictions, and I need to know which one are you operating up under now. How could you?
You do, Mr. Michaud. The court's answered the question multiple times, and the court deems this matter concluded. I will see you next Wednesday afternoon.
Check to that.
Your Honor, ma'am. Just for the record, his out date right now is February 24th. And if your clerk can send over paperwork, that way we have this case, this date and everything in the computer.
Understood, Mary Ann. We'll take care of it. Thank you. That concludes this matter, Mr. Michaud. I'll see you next Wednesday. You have a good afternoon.
I was not able to get the next hearing. I know on Team Skeptic, he was able to get that hearing, so you can probably go over there and find it. I'm not sure which of the other channels was able to grab it, but it was one where he had to stand up in front of the judge. I can't even remember what judge it was. But yeah, he's definitely a full through the go. You were asking about, is there a Solvsit handbook? I know here in America they have seminars for them. They have Facebook for them. They sell them information. They'll basically offer them, $500 and we'll give you all the information so you never have to have a tag. And it's just a scam. It's a scam for the weak and a scam for the silliness. this guy here is a perfect example of the silliness. I don't begin to understand it. I think it's just a stall tactic. They just want to wear down the police. I see the police giving them way too much opportunities. I see the police giving them way too many options. But I think he ended up pleading to it later on. But I know the next court hearing, he tried the same garbage with the next one. I don't know where it ended up at. But I'm gonna show I'm gonna show Judge Oakley's new courtroom. Yeah, on Friday, Judge Oakley has his cameras set up right in his courtroom where you can see everything. So we're going to do a hearing or two there. Nothing was really exciting, but I liked how we could see the courtroom and see all the tables. So here we go to that.
Thank you, ma'am. Your Honor, Ms. McCullough is not contemptuous, but she is struggling. And Mr. Rowley's been working with her. She has some items that the court has requested that I believe Mr. Rowley feels
I'm with you.
some sort of failure or something. So after discussions with Mr. Rowley and Ms. Ford, Mr. Rowley's suggestion, which we would agree with, if we close this with
Just close it unsuccessfully.
I don't believe, given her current financial status and everything, that she's willing or able to decline.
and I believe but I've explained to her, the money will continue to be a debt.
Yeah. Where are you working at, Miss McCollum?
I just started at Tim Hortons out
Okay.
here in Flat Rock.
How many hours you getting?
Like 4 to 5, maybe. I did 4 Saturday and Sunday, and 3 Monday and Wednesday, and 5 Tuesday. Today I'm off, and tomorrow I'm off.
Okay, I'm assuming you heard what Mr. Bowdish just told me.
A little bit. It's kind of hard to hear, but a little
Okay,
bit. Yeah.
all right. You can hear me okay?
Yes.
Okay, all right. So what he said was that you were okay with Ms. Tiroli's suggestion that we close this file unsuccessfully and just send you to work out some kind of a payment arrangement with our collections department.
Yes, that's fine. Thank you.
Okay. All right, I'll do that. Good luck on that job. Hopefully they start giving you real hours.
Yeah, I hope so too. Thank you.
Thank you.
You're welcome. All right, you're all set, ma'am. I'm going to kick you out of the meeting.
Okay, thank you.
Which one's next, Mr. Powder?
Gissendamer.
Come on up.
I've explained I see he were my kids. Your Honor, for the record, Jeffrey Bodick appearing on behalf of and with Mr. Gissendamer. After all these meetings, I know how to pronounce his last name. You tell me your last, or your first and last name.
Thank you.
Your Honor, I believe we had good, last time we were here, we did not have good news. We did not have a focus, we did not have a future, we did not have a job. Mr. Gissendamer is employed.
Where at? Where at? Good. How many hours are they going to give you? Full time. Awesome. Awesome.
He also is waiting on a second job possibility at a manufacturing plant, I think that works with the auto industry.
Good. Good.
So
Where's that at?
The name of the company, I'll recommend it by a family friend.
Okay. Felicia? Say again? Okay. Okay. Dad, right? Yeah. State your name just because you spoke on the record. Thank you, sir. All right.
what happened, Your Honor, there was some sort of epiphany that seemed to roll over Mrs. Gissendaner. And he went out and did some work.
Okay. What else? I mean, that's good news, but what else?
Also, it's the first time I'm waiting on the response to see what the customer is.
Okay. Man, if you could get into U of M, that'd be awesome. I don't know if it's still true, but for a while, if you were an employee at U of M, you got some like really sweetheart deals on tuition. And they had, go ahead, Dad.
Oh, yeah, still possible.
Yeah. Yeah.
A lot of discounts on a lot of other stuff, we just.
Yeah. Yeah, yeah, man, good luck there. All right.
Yeah, Your Honor, he hasn't got to start getting paychecks yet, but
No, I understand that.
he understands the commitments.
He's got a possibility of a paycheck now. If you don't have a job, you got no possibility of a paycheck.
And I think he's ready to make the monthly commitments.
Okay,
Signed to an issue.
okay, all right. Brother, I gotta ask you, how was your 2 days in jail?
Very well.
Where did you do your time? All right, so they just kept you locally. Yeah, man, that's a blessing. I mean, it's probably bored you out of your mind, probably like you've never been bored before, but at least you weren't in Wayne County Jail.
Not like sound those metal doors, dude.
Man, why'd you make me do that to wake you up? Thank you for that. Seriously, thank you for that. Mr. Oley?
Would you like to extend his probation just so we can keep an eye on the record?
For 4 or 5 years, I'd like to extend his probation. I can't do that. I don't have the authority. We haven't gotten any money yet on restitution, have we?
We have this maybe.
Okay.
Was on the 26th of last.
Okay. All right. So how much are you comfortable committing to based on the Walmart job? Because we don't have any other job lined up yet. Is 150 doable? Okay. All right. Okay. Okay. Yeah, Dad, go ahead.
Well, go a little bit more than 150, we can always rearrange that, right?
Can you ever imagine me saying no? In any reality, can you imagine me saying no? Okay. All right. I think that's our big issue, right? Money?
That's the last thing, it's just restitution.
Okay. Okay. All right. All right. So what's the balance on the restitution right now, Ms. Trolley?
$1,148.
All right. So at $150 a month, it takes more than 7 months to pay that off. So here's what I'm going to do. I'll extend your probation 6 months. I don't want to see you again. I'm going to tell you right now, I am not going to close your file without a face-to-face. I don't want to see you again until that 6 months is up, or you're asking me to close you out early because the money's been paid off early. Okay? But I do want to see you again because I want to know what's going on. I don't want to just know that you've been making your payments. I want to know what's going on. What's the plan? Okay? All right, that makes sense?
Yes.
Okay, all right. Got it? Dad, we're okay with that? All right, okay. All right, good luck. I hope you get the U of M job. And I hope they work you 70-hour weeks. All right. Yep. Good luck, Mr. Gissner. Council, are we ready on, I'm going to pronounce it Pumphrey? Well, I didn't notice that, but he seemed to know what he was talking about. Council, your appearance, please.
This honorable court director David Kramer on behalf of Mr. Pumphrey.
Same here, Council. Have you fellows had a chance to go over the report and recommendation? Any corrections? Jamie, any news?
No, nothing. I just got a call from, they have some stuff going on.
Okay,
No show.
thank you. I'm sorry, Council. All right, so no corrections.
No correction.
Allocution? Allocution?
Never had anything, as it relates to the law. He's never been in trouble with the law. He's actively employed at DTW, SkyWest. He's a fine young man.
Full-time, I'm sorry, full-time hours? Go ahead.
And he's a fine young man. This is an aberration that will not happen again.
Okay, okay. All right, Mr. Pumphrey, don't feel that you have to, but I want to give you a chance to talk if there's anything you want to share with me personally. I said, don't feel that you have to talk, but if there's anything you want to share with me, this is the time to do so.
Sorry, eye opener. I messed up and it ain't gonna happen again. I'm sorry.
Okay. All right. So here's my big concern. On June 20th, I put you on a bond, and that bond was no mood altering substance, was not a doctor's prescription, but you continued to drink and smoke.
I think once it's
Okay. That's a major concern when I'm getting ready to put you on probation and tell you to do what I tell you to do. All right. So, I'm still going to go along with the recommendations for probation, but I wouldn't feel good if I didn't tell you this before I do that. You had your mulligan. Okay, you violated my bond twice. You had your mulligan. If you have any slip ups now, you better be the one that brings it to our attention. We better not catch you. Am I making myself clear? Okay. All right, so once again, I'll adopt the recommendation Mr. Tiroli put on paper. You and council saw it. It was 10 recommendations. Those are now 10 court orders. 12-month probation. Probation cost is $480. The total money is $1,300. You can talk to Mr. Tiroli about that. And good luck.
Your Honor, if he is successful and has no violations, will the court consider,
Always consider that request.
Thank you.
Always.
Good
Yep.
to see you.
Have a good day, gentlemen. What's your name? Last name? Come on up. Have you waived the right to talk to a court-appointed attorney today, Mr. Lucas? Okay. All right, so Mr. Lucas, we've got a file here. It goes back to October of last year. Sentenced you on April 11th. Let's see what we got. One problem, big one, but one problem. You're on track with everything except the treatment. Says here you had a therapist appointment on the 9th of July.
Yeah.
Where are you working at?
Miller Industries and Family.
What do they do?
We make industrial air movers.
Okay, okay. Long job? Had it for a while?
Yeah.
Good, good, okay. All right, so if I'm reading this right, you got a money problem. Okay, all right, Mr. Tiroli?
I have full custody of both of my kids with no child support.
Okay. Okay,
He did provide documentation of completed community service when he.
good, good.
He is.
On everything else? Yeah,
Orders to obligation in lieu of.
any priors in CCH?
There is a prior opioid from 2015.
It's 10 years ago. Okay. Was the substance abuse treatment based on an evaluation that we had done or based on the needs?
Based on the needs, Your
Okay.
Honor.
All right, so your suggestion is we amend the treatment to education. What do you think of that? Right, right. And Mr. Lucas, what do you think of that suggestion?
I'm on board with it.
If nothing else, you should be able to find someplace a heck of a lot cheaper. I'll go along with it. Wish you luck. You're welcome. Drive safe. We're not supposed to have anybody else in Zoom, right?
No.
Okay. And you got something ready, Mr. Bowditch?
Yes, sir. I'm ready on Miss Moore.
Come on up, Ms. Moore. Mr. Bowditch, your appearance, please.
Record. Everybody appearing on behalf of the Miss. Ma'am, can you tell the judge your name, record, Mr. Solomon?
Good afternoon.
Your Honor, today's date and time, set for a hearing in this matter. There was some questions about community service. There was some questions about a therapist and a positive test. She hasn't been seeing a therapist. The problem is that it has not been communicated correctly to Mr. Rowley. she can respond to the community service and the positive testing.
Okay, go ahead.
Surgery in 2021, and there's a absorption issue with like vitamins and stuff, and so they, because of bad blood work that came back, they had me taking extra iron and extra multivitamin. And to be honest, I was super constipated. So I think that test was because I was taking or drinking kombucha, which is like a natural probiotic trying to help move things along. And I was tested after that. That's the only thing that I've done.
Okay.
That's the only thing that I can think that would have, caused a positive test.
What about community service?
Related to the locations that are available, I applied to the Leslie Science Center, the 240 Church, and another one that's in Ann Arbor. I don't have a car right now.
Any nonprofit charity will be acceptable to me.
Yeah, there's something.
As long as it's a registered, when I say registered with the IRS, nonprofit, perfectly fine. Doesn't have to be on our list. That we do the list, so it's hopefully it's easier for folks. They don't have to find something. Understood. Understood. No. If you find someplace you can get to easier, but as long as it's not, and if you're worried about it, have her pre-approve it before you put in 10 hours. Okay. So get something from the agency, contact her, email it, whatever. Okay. I'm sure it's a nonprofit, but let her confirm it. Okay. Yeah. Okay. All right. So the main problem we've got is her lack of communication with you. So that's got to be fixed, because we're fairly nice people, but here's the problem. If we can't get answers, we assume the worst. You're avoiding us. Why would you avoid us? Because you're doing things we don't want you to do. That's just how our minds work. Okay.
I asked for an explanation of benefits. I just told Mr. Bowers, my therapy visits have all been by Zoom. I've never actually met my therapist.
Right.
So in order for her to talk to someone, she sent me a medical release.
Release. Sure.
And then I had to,
Yeah.
I'll talk to her.
Just better communication.
Yes.
Better communication.
Directly talk to Mr.
Okay. Okay.
But I do have those EOB statements from Cross where it shows, the ability for the visit. And
Right. Right. Well, here's the thing though. We don't want to just make sure you're going. We want to make sure the therapist says you're participating.
did a release off.
Yes, that'll do it. Yeah. Yeah, that makes sense. How far out you want to go?
Or October then.
You tell me. I want you to make my tail wag next time you see me. So how much?
That will give me time. I'll work on transportation and everything too, so that will help.
What was that date? October what? 8:30. All right, we got a plan?
Yes. Currently, I have all of the medications for some.
Perfect.
With.
Perfect. No, that'll work. Okay. All right. Good luck with your health. You're welcome.
Hey everybody, there's not really a lot more going on with this hearing day in here, but that statement begs more questions. I feel compelled to leave it alone. Absolutely, Fozzie. I'll just leave it with this. Julie, you brought up a good conversation starter. When I was a young kid, my mom had rough days, and I never really knew what it was. Now, as I've gotten older, and as my wife has taught me, I know more about my mom than I ever knew, and I know why sometimes she was not having good days. But I also learned to leave. I left my mom alone, and I'm leaving my wife alone. So I do plan on not being stabbed. And so thank you guys so much for coming out. Thank you. 800 comments today. So thank you so much. I think 40 or 50 of them was from that young YouTube channel. Boy, wasn't that fun. All right. Thank you so much, everyone, for coming out. I really do appreciate it. Tomorrow night is Monday, and we should be back to new court stuff. I don't know if it was just depression from Judge Fleischer being out or just in a funk, but I couldn't really find much court worth anything this week. And what I did find was on videos I had already in the system. So thank you guys so much. It says give them whatever. Absolutely, Julie. Give them whatever they want. I always will. Hey, legal. Thank you. Calling rate of 1. Appreciate it. The other night I tried to send everybody over to his channel, but he had stopped right before I stopped, so it just all worked out. If you ever think your parents are growing with you, absolutely. by lethal friction. Lethal friction. It doesn't seem right if legal fiction and lethal friction aren't in the same room. It seems like they should be. All right. Thanks, Fozzie, for coming out, and Emily, and Roll on G, and Sivo Girl, and Nan, and everybody else. I really do appreciate it. Julie, thank you for stopping by. Jasmine, thank you. Roll on Green, I think she's probably already went to bed. She was already tired. Thank you so much, everybody, and we'll see y'all tomorrow night.